Welcome to Doctor Not Guilty, Series 4, Chapter 4. Take the Fifth. My journey began long before I ever stepped into a courtroom. In 1988, my father started taking contract work in the United States, traveling constantly back and forth between Syria and America. By 2011, the escalating chaos and violence of the Syrian civil war made remaining in Aleppo completely impossible, forcing my parents to pack what little they could, leave everything behind, and relocate permanently to the United States. By that time, my own path in life was already moving forward. Back in 1989, my older brother Arif had moved to Memphis, Tennessee, to begin his medical residency. Shortly after graduating from high school in Syria, I boarded a plane and joined him there in Memphis. Adapting to the fast, loud, and unforgiving rhythm of American life was an intense, dizzying transition for a young man from Aleppo. To support myself financially and pay for my education, I took a job at the central distribution hub for FedEx in Memphis, working the brutal graveyard shift from 7 p.m. in the evening until 7 a.m. the following morning. Night after night, under the glare of harsh industrial floodlights, our crews manually unloaded massive 20 to 30-ton cargo planes and sorted tens of thousands of heavy parcels against unforgiving, relentless deadlines. Walking out into the morning air at dawn, soaked in sweat and utterly physically exhausted, I learned what raw, unyielding discipline really meant. Despite that demanding work schedule, I refused to let my medical aspirations fade. During the day, I volunteered as a clinical helper in the emergency room at the Veterans Affairs Medical Center in Memphis. Caring for American military veterans who bore deep, agonizing wounds, both visible physical injuries and hidden psychological trauma, completely transformed my life perspective. Sitting at their bedside, listening to their personal struggles, I realized with absolute clarity that I was called not merely to haul heavy boxes on a tarmac, but to carry the profound emotional and physical burdens of human medical care as a physician. Driven by that renewed sense of purpose, I returned to Syria to enroll in an intensive 6-year medical school program in Aleppo, where the local political atmosphere had temporarily stabilized enough for me to throw myself entirely into rigorous academic study. Yet every single summer, while other students took vacations, I bought a flight back to the United States to continue gaining invaluable medical and research experience. During those intensive summer months, I worked long hours as a neurosciences laboratory technician at the University of Tennessee, participating directly in cutting-edge brain research. Operating complex laboratory instruments and observing the subtle, intricate mechanics of human neurological pathways solidified my lifelong passion for psychiatry and mind-body medicine. At the exact same time, to fulfill obligatory obligations in my home country, I completed mandatory military hospital training in Syria, spending 15 grueling days enduring intense physical drills in the scorching desert heat. Looking back, those 3 distinct environments, the sun-baked Syrian desert, the midnight FedEx loading docks, and the quiet neuroscience laboratory, each built something indispensable within my character: mental stamina, absolute precision, and an unshakable capacity to remain calm in the middle of terrifying chaos. Those exact psychological qualities become vital survival tools when you find yourself caught in high stakes, life-altering legal battles against the federal government, such as the fight faced by Dr. Michael Bahrami. When the jury retired to deliberate on his case and unexpectedly signaled they had a verdict after less than 45 minutes, profound terror gripped everyone in the courtroom. Dr. Bahrami was facing a multi-count federal indictment centered on healthcare fraud and conspiracy charges. To make matters vastly more terrifying, 2 of his co-defendants, fellow medical professionals, had already buckled under government pressure and entered guilty pleas. Yet through the entire ordeal, Dr. Bahrami stood his ground and strictly adhered to his defense attorney's primary instruction: say absolute nothing to federal investigators, and offer zero commentary to prosecutors. While sitting in agonizing silence inside that courtroom, waiting for the verdict to be read, his mind wandered back to his youth, remembering when he fled Iran during the violent upheavals surrounding the 1979 Islamic Revolution. He had arrived in the United States at just 17 years old, speaking minimal English and possessing almost no money. He began his American journey washing dishes in greasy restaurant kitchens in Florida before working relentlessly to put himself through Rutgers, New Jersey Medical School, followed by an exhaustive internal medicine residency and a prestigious cardiology fellowship. Now, at 59 years old, with a flourishing practice and 2 young children waiting at home, he was looking at the real possibility of spending up to 5 years inside a federal prison cell. But when the clerk finally read the jury verdict in that Miami courtroom, the words rang out, "Not guilty on all counts." His wife burst into uncontrollable tears of profound relief. During the trial, federal prosecutors had introduced over 30 secret video recordings, attempting to portray standard clinical decisions as part of a criminal scheme. However, because Dr. Bahrami had firmly exercised his right to remain silent, prosecutors had no misleading statements, no unrecorded interview transcripts, and no off-the-cuff admissions to twist against him. His silence had shielded him from self-incrimination and ultimately saved his freedom, his career, and his family. To understand why silence is your single greatest asset during a government investigation, we must examine the constitutional foundation of the Fifth Amendment. The Fifth Amendment to the United States Constitution states clearly that no person shall be compelled in any criminal case to be a witness against himself. This fundamental privilege was created by our nation's founders specifically to protect citizens against the vast coercive power of government authorities. However, most physicians and professionals suffer under a dangerous legal misconception. They assume that if they have done nothing wrong, their natural silence will automatically protect them. That assumption is a catastrophic error under modern constitutional law. In the landmark United States Supreme Court decision, Salinas versus Texas, handed down in 2013, the Supreme Court radically altered how the Fifth Amendment operates in pre-arrest situations. In that case, an individual voluntarily answered several questions from police officers during a murder investigation, but when officers asked whether ballistics tests on his shotgun would match shells found at the scene, he simply froze, remained silent, and looked down at the floor. Later at trial, prosecutors argued to the jury that his sudden silence and nervous demeanor were clear evidence of a guilty conscience. The Supreme Court ruled 5-4 against the defendant, establishing a precedent that every practicing physician must memorize. Remaining passively silent is not enough. The court held that the Fifth Amendment privilege against self-incrimination is generally not self-executing. If you simply stand mute or refuse to answer specific questions without explicitly stating your legal grounds, prosecutors can and will use your silence in court as evidence of guilt. To receive constitutional protection, you must expressly, verbally invoke your Fifth Amendment rights. You must say out loud, "I am invoking my Fifth Amendment right to remain silent." This requirement creates a terrifying legal trap for doctors. Physicians are accustomed to sitting down with clinical auditors, hospital board members, and regulatory officials to explain complex medical decisions. When federal agents, whether from the Federal Bureau of Investigation, the Drug Enforcement Administration, the Department of Health and Human Services Office of Inspector General, or state medical boards show up at your practice, your immediate human instinct is to explain, clarify, and resolve what you assume is a simple misunderstanding. But in the eyes of federal law, the moment you begin speaking without a lawyer present, every word you say and every question you suddenly decline to answer is being compiled to construct a case against you. The risk is not limited to direct interviews with agents. Even relying on high-powered legal counsel to negotiate informally with federal prosecutors can lead to devastating consequences if proper boundaries are not maintained. Consider the high-profile federal prosecution of United States Senator Robert Menendez in 2024. Prior to the formal indictment, defense attorneys submitted a comprehensive legal presentation to federal prosecutors, attempting to explain away suspicious financial transactions and show that their client had engaged in no wrongdoing. Instead of convincing the prosecutors to drop the case, federal prosecutors analyzed every factual representation in that defense submission, declared the factual statements to be deliberate falsehoods designed to mislead the government, and added federal counts of obstruction of justice directly into the indictment. The very statements submitted by legal representatives to defend the client became powerful prosecution evidence used to secure a conviction. If seasoned defense attorneys can inadvertently provide prosecutors with ammunition for an obstruction charge, imagine how vulnerable an individual physician is when attempting to explain complex medical billing or prescribing habits during an unexpected visit by government investigators. I speak about this not merely as an abstract legal theory, but from personal, agonizing experience. When federal agents first knocked on my door, they used warm, professional, and entirely disarming language. They assured me that they were simply conducting a routine inquiry, that they merely needed to clear up a few minor administrative details, and that I was absolutely not the target of any investigation. Every psychological instinct in my body urged me to sit down, open my files, and explain the intricacies of my psychiatric and internal medicine practice. Thankfully, my defense attorney gave me clear, unwavering advice. Say nothing, answer 0 questions, and insist on total silence. Countless doctors make the fatal mistake of talking because they firmly believe that truth is an impenetrable shield. They think, I have dedicated my life to healing people, I followed clinical guidelines, and once these agents understand my clinical rationale, they will close the file and leave. What doctors fail to realize is that federal investigators operate in an adversarial system where truth is regularly reinterpreted through the lens of prosecution theories. When federal agents interview a suspect or witness, they almost never record the conversation on audio or videotape. Instead, 2 agents usually conduct the interview. One asks questions while the other takes manual handwritten notes. Afterwards, the agents draft a formal document known as an FBI Form 302 or an equivalent investigative report. This report is not a verbatim transcript of what you said. It is a selective summary written hours or days later, phrased in the agent's own words, and tailored to support their investigative narrative. When your case goes to trial months or years later, the jury will not hear what you actually said in that room. They will read the Form 302 written by the agents. If there is any discrepancy between your recollection of the conversation and the written report signed by 2 federal agents, the court and jury will almost always accept the agent's version as absolute fact. A single innocent remark, a misremembered date, or a poorly worded explanation about a patient chart will be framed as a deliberate material lie, exposing you to felony charges under Title 18, Section 1001 of the United States Code, for making false statements to federal authorities. Consider the heartbreaking story of Dr. Ajib John Titus, a devoted family practice physician who had served his local community with distinction for decades. On a late Thursday afternoon in March 2018, Dr. Titus was finishing up his workday when a patient arrived late, desperate for a routine medication refill. Being a compassionate clinician who always put patient needs first, Dr. Titus stayed well past 5 p.m. to evaluate the patient and provide the necessary prescription care. What Dr. Titus did not know was that another individual, recently arrested on severe drug charges, had falsely pointed fingers at Dr. Titus in an effort to secure a favorable plea deal for himself. Shortly thereafter, a state narcotics investigator arrived at Dr. Titus's office asking for a quick 45-minute informal chat. The investigator was polite, reassuring, and explicitly told the doctor that he was not in any legal trouble and that answering a few questions would help clear up a minor matter. Believing he had nothing to hide, Dr. Titus sat down without an attorney and answered every question with complete honesty, explaining his clinical practices and his dedication to patient care. In September 2020, federal and state authorities returned with an arrest warrant, taking Dr. Titus into custody. Prosecutors took his honest statements from that 45-minute interview, stripped away the clinical context, and distorted his after-hours dedication into supposed evidence of illicit prescription distribution. Had Dr. Titus simply invoked his Fifth Amendment rights and refused to speak without counsel, prosecutors would have lacked the narrative foundation necessary to bring those devastating charges. If you think that advanced professional training, high intelligence, or extensive experience in high-pressure environments will enable you to outsmart federal investigators during an interview, consider the case of General Michael Flynn. General Flynn was a retired lieutenant general in the United States Army, a former director of the Defense Intelligence Agency, and a highly decorated intelligence officer trained extensively in national security, counterintelligence, and interrogation tactics. When two FBI agents visited General Flynn at the White House for an unannounced informal chat, General Flynn believed he could navigate the conversation smoothly without needing a lawyer present. During that brief, seemingly casual discussion, Flynn answered questions regarding his communications with foreign diplomats. The investigators later drafted their Form 302 report, claiming that Flynn's answers contradicted intercepted communications. That single casual interview resulted in a federal felony indictment for making false statements. If a highly trained national intelligence chief can be ensnared during a casual conversation, a medical doctor stands virtually no chance of talking his way out of a federal investigation. The structural imbalance in these interactions is profound. Federal investigative agencies operate under institutional policies that generally prohibit electronic recording of interviews, precisely because unrecorded interviews allow the agent's written summary to serve as the definitive, unassailable legal record. Your actual spoken words matter far less than what the investigating agent writes down on his notepad after you leave the room. In federal court, the agent's notes prevail, a harsh reality that was demonstrated when major national corporations like Arthur Andersen were destroyed through federal obstruction allegations long before higher appellate courts could review the legal overreach. Physicians are trained from the first day of medical school to be open, empathetic communicators. We are taught that thorough dialogue, detailed history-taking, and clear explanations build vital trust between doctor and patient. However, when you step out of the clinical environment and enter the realm of a criminal investigation, that deeply ingrained clinical instinct to explain becomes your single greatest vulnerability. Investigators are trained interrogators who utilize specialized psychological techniques designed to put you at ease, make you feel guilty for remaining quiet, and exploit your natural desire to defend your professional reputation. During my own federal prosecution, government agents went so far as to assert on the witness stand that I had made incriminating statements during an encounter that lasted less than 2 minutes, an interaction where I had done nothing more than hand them my attorney's business card and decline to discuss the case. They attempted to spin my refusal to engage into evidence of suspicious conduct. This experience taught me an indelible lesson. When dealing with state or federal investigators, there is no such thing as off the record. There is no such thing as a friendly clarification, and there is no such thing as a harmless conversation. To effectively protect yourself, you must understand the exact protocol to follow if law enforcement agents approach you at your office, your home, or a medical clinic. First, maintain total physical composure. Do not act aggressive, defensive, or panicked. Second, clearly and unambiguously state your constitutional position out loud. You should say, I am exercising my Fifth Amendment right to remain silent, and I will not answer any questions without my attorney present. Third, immediately request the business cards of every agent present, hand them your attorney's contact information, and decline any further discussion. Do not engage in small talk while walking agents to the door. Do not offer them coffee. Do not comment on the weather. And do not attempt to justify why you are invoking your rights. Remember that under the precedent set by Salinas versus Texas, any hesitation, selective silence, or partial answers can be weaponized in court. You must maintain complete, unbroken silence from the moment you state your invocation until your legal team takes over all communications. Let your silence act as an impenetrable shield around you. The ultimate takeaway for every physician, healthcare executive, and professional listening to this podcast is simple and absolute. Talking to law enforcement during an investigation can never, ever help you. Federal agents and state investigators do not conduct interviews to gather information that will clear your name. Their sole objective is to collect evidence that can be used to construct a criminal case and secure a conviction. Your words, no matter how honest, well-intentioned, or clinically justified, can and will be reframed, taken out of context, and used against you in a court of law. Never talk to police officers, never talk to federal investigators, never talk to medical board inspectors, and never talk to government prosecutors without experienced legal counsel standing at your side. Absolute silence is the most potent, legally protected weapon you possess to safeguard your medical license, your professional reputation, your personal freedom, and your family's future. Always remember these 5 indispensable words: say nothing and save everything. To understand the full scope of how federal regulatory bodies exploit administrative authority to bypass constitutional protections, we must examine the intersection of civil administrative audits and criminal prosecutions. Often, a healthcare provider receives a seemingly routine subpoena or notice of audit from a state medical board, Medicare administrative contractor, or Medicaid fraud control unit. Physicians frequently view these administrative audits as minor regulatory compliance matters, failing to realize that civil administrative agencies routinely operate in close coordination with parallel federal criminal investigators. This practice, known in federal law as a parallel proceeding, allows law enforcement agencies to utilize civil discovery mechanisms, administrative subpoenas, and compulsory regulatory depositions to collect evidence that would otherwise require a formal criminal search warrant or grand jury subpoena. In many cases, statements made by a physician during a civil administrative deposition or answers provided in a routine state medical board interview are shared directly with federal prosecutors, effectively circumventing traditional Fifth Amendment safeguards if the physician fails to explicitly invoke their rights during the civil proceeding. The legal principle governing this risk was established in key administrative law precedents, where federal courts held that evidence obtained during a civil audit can be fully admissible in a subsequent criminal trial, provided the government did not engage in outright trickery or affirmative misrepresentation regarding the existence of an ongoing criminal inquiry. However, because federal agents and administrative investigators are under no legal obligation to inform you that a civil audit has morphed into or is running parallel to a criminal investigation, every administrative encounter must be treated with the exact same level of legal caution as a direct criminal interrogation. Furthermore, physicians often operate under the mistaken belief that hospital peer review committees, quality assurance panels, and local medical society ethics boards are safe spaces where open dialogue is protected by professional privilege. In reality, peer review proceedings, internal hospital communications, and administrative committee notes are readily subpoenaed by federal grand juries. Voluntary disclosures made to hospital administration or peer review boards in an effort to explain billing discrepancies, patient care decisions, or prescribing patterns can be subpoenaed, parsed, and introduced as prosecution exhibits in a federal courtroom. When faced with any inquiry, whether civil, administrative, institutional, or criminal, the foundational rule remains unchanged. The physician must establish an immediate legal barrier by retaining legal counsel, invoking Fifth Amendment protections where appropriate, and directing all communication through qualified attorneys. By enforcing strict boundaries across both administrative and criminal domains, you prevent the government from utilizing parallel civil mechanisms to construct a criminal case. Let us also examine the psychological pressure tactics deployed during federal knock and talk operations. Federal investigators frequently execute visits during off hours, such as early morning at a personal residence or late afternoon at a busy clinic, intentionally designed to capitalize on surprise, fatigue, and emotional vulnerability. Agents may imply that seeking legal counsel is an admission of guilt or suggest that cooperating immediately without an attorney will result in more lenient treatment or avoid public embarrassment. These psychological strategies are deliberate legal maneuvers aimed at inducing a waiver of constitutional rights before you have the opportunity to consult with legal defense counsel. Recognizing these tactics for what they are, high-pressure interrogation methods dressed up as informal conversation, is essential for maintaining complete psychological discipline and protecting your constitutional rights under any circumstances. In summary, whether dealing with federal law enforcement, state narcotics agencies, medical licensing boards, or hospital regulatory committees, your duty to yourself, your family, and your medical career is absolute. Invoke your Fifth Amendment rights verbally and explicitly. Decline any unrecorded or informal interviews. Refrain from attempting to explain complex clinical actions without defense counsel. And ensure all communications pass through your attorney. Your silence is not an admission of wrongdoing. It is your ultimate constitutional shield.